a show where I try to educate real stories. Thank you for watching Truth and Justice with Vivian King. We have another exciting show planned for you tonight where we hope to educate you about Harris County jurors' current attitude towards trace cocaine cases. In the studio, I have my good friend and great lawyer, Mrs. Juanita Jackson, and she will talk to you about two of the current cases that she's tried to great two-word verdicts of not guilty in cocaine trace cases. And through those two cases, we are going to do like a case study to see what the facts are and what people's current attitudes are. So without any further ado, Juanita, educate us on what's going on with trace cases right now.
Well, to people's surprise, that trace cases are being brought. They are even being tried here in Harris County. Meaning, if you don't take their offer of Harris County jail time or state jail time, the district attorney's office is willing to try them. And something is, when we call a trace case, is technically any amount that goes to the lab that cannot be weighed or quantified. I like to say, and I question the lab techs, basically that you can run your finger over something. It would be even a residue case is what we call them. The most popular ones are the two kinds of cases that I tried, which are what we call pipe cases. They were crack pipes that had been smoked up, everything had been smoked, and then all that was left was the residue, okay? That's the case in both of these cases. The facts of them were very different.
Okay, let's take one at a time.
Mm-hmm. Yes. So the first case that I tried, my client was essentially a homeless man who the police officers' probable cause for coming up to him and stopping him, they believed and suspected him of panhandling at a nearby downtown area.
Do you remember if it was day or night?
It was daytime, broad daylight, probably about 11 o'clock in the morning. And the officer claims that my client was panhandling. They approached him based on their suspicion of panhandling. And then from that, claimed they were arresting him for panhandling. And in search of his items, his bags and things like that, inside his backpack was a crack pipe. So despite everything, my client was adamant that he wanted a trial on that case. It was very unusual in the fact that the state got to the point that they had offered him time served, but he refused it.
About how long did he stay in jail before he got the time served offer?
Significantly, I would say at least 6 months by that time. And so that would have put him out of jail, but he was adamant that he wanted a trial, mainly because his point was that he wasn't panhandling. So we went to trial based on the lack of probable cause. We also did a motion to suppress. I did all of, when I say we, I did all of these things, and we were challenging the legality of the panhandling statute and challenging whether or not the cops could even see if he was panhandling. In this case, so many things about the cops' recollection of where he was, where the car was. The two cops, their stories were different, ultimately. And in the end, the DA got caught up on all of that part, trying to make the legality of it.
What is the law on panhandling?
The law on
Isn't it a city ordinance?
It is a city ordinance.
Okay.
It is a city ordinance, and that they cannot solicit people for any monetary gains. So the point was, the cops couldn't tell what he was talking to the people for. They never questioned the other person. Was he panhandling? So we dealt with that aspect of it.
Let me ask you another question. Also in the panhandling statute, it's my understanding that they can't be in the street impeding traffic. Is
Right.
that a section of it?
Right, it is. It's a section that they can't be impeding, and they cannot, and in this case, they went on the aspect that it cannot be certain feet away from a gas pump.
Okay.
So the statute is really specific and geared towards people panhandling and gas stations. If they are on the street, it's not panhandling. So when you see people standing on the corners and that passive panhandling, that's not panhandling. Right. Panhandling is when you are within a certain feet of a business or a gas station pump.
Or in the street.
Or
in between those car lanes, because I know that they added that to the statute.
Right, right. So that's why they wholeheartedly stay on that median or stay there. Okay. But in this case, trying to prove where my client was the issue. What we do as lawyers, it's not the issue in this case. There was a crack pipe in a bag. They had no proof if it was his or not. That's an issue. But also the issue of ultimately, he wasn't suspected of using crack. He wasn't seen using crack. Their whole rationale for stopping him was panhandling. And in the end, they found a crack pipe in the bottom of his bag.
So that the officers in trial, with a straight face, say that they were going to arrest him for panhandling?
Yes.
Okay. And what position did they say he was in? In the street, near the gas pump?
They said he was near the gas pump, and he was near the gas pump.
How close did they say he was?
They said within 3 or 4 feet, which would have been, because he has to be by the statute, if I'm recalling correctly, 10 feet away from the pump. So where he said he was, so we get to the fact that the motion to suppress was not successful. But in the end,
let me stop you there on our educational tip.
Yeah.
All right. The motion to suppress is to say he has a right to be left alone. You have to have probable cause to unreasonable search and seizure. Was it reasonable to search him under the law? Did the police officers see a crime within their view? Let me ask you this. Could you also have gone, could you go under where officers can stop you? They have to see a felony or a breach of the peace, but I guess they're saying he's just being arrested for a Class C misdemeanor.
Right, exactly.
Which is crazy.
So it was no felony. They didn't see anything. They never suspected him of drugs. It wasn't until they got to the station and his bag was totally inventoried, and in the bottom of the bag was a crack pipe. Okay. So he was taken into custody for panhandling. Now, the client's position is, and to wholeheartedly believe it, he was a little lippy with the officers. He was asserting his rights. He was very vocal, and we all know that that's how you end up getting these trumped up minor offenses such as panhandling. I got the officer to admit he had never even arrested anybody for panhandling before. But my client was being probably arrogant and obstinate. So in the end, he arrested him for panhandling, was charged with the crack pipe. That ultimately, the issue in this case was there was no proof that the crack pipe was his. The fact that it was simply in a bag that may have been at his feet, the cops didn't remember where the bag was when they took it in. So the jury ended up saying, you know, they just didn't do enough to prove that this crack pipe in this backpack was his. The cops said they didn't have any ID, they didn't have anything. So I was able to prove that even though we were trying to prove that there was no probable cause, the jury didn't really buy that. But they did ultimately say the state did not prove beyond a reasonable doubt that the crack pipe in the backpack could indeed be my client's, or was indeed my client's.
So there was no identifying marks that associated him with that backpack?
Absolutely. And the thing that's similar in both cases that juries ended up not liking is that the police are making such a big deal about this being their crack pipe, but they did nothing to determine. There was no fingerprints, there was no testing, there was no things that are within their realm to say this was this person's crack pipe. The reality is, do we, as taxpayers, and the juries talked about that, are a little offended about how much money we spent to try a case for a trace in a crack pipe.
And was this a 2-day trial?
It was a 2-day trial. Both of my cases were 2-day trials.
So that means people are taking off work, 12 people are taking off work to be there to decide something that I think jurors feel like we should be able to decide that as lawyers. Prosecutors and defense lawyers should be able to work this out.
Right.
Don't you believe that?
Yeah, I think that they believe that, but in the end, The problem is, and we normally do work these cases out, the bottom line is not that many attorneys will even, I say, go through the process or bother to try a trace case.
But let me expand that a little deeper. When I also say the jurors' attitudes about it, I mean the current administration of the district attorney's office and the police arrest people for these crack pipes. But we know under Pat Lycos, they weren't arresting people for that.
Right.
And that was kind of like the will of the people. And to me, I remember when I was a prosecutor, Johnny Holmes used to tell us, do what the people want. You know, so the people, to me, have spoken that these cases are just not worth our time, so we should not be arresting people for it. I mean, we're not saying it's not a crime, but why do we use all of our investigative resources to determine? Because remember, a crack pipe, audience, it's nothing. You can't see it's not a usable quantity of cocaine. It might be, I might pick up something off the ground that might have a little vial, and I'm gonna keep it to put something in there. But it could have crack cocaine, a trace of crack cocaine in it. So do we really want to use taxpayer resources to get officers off the street, book people into jail, use all of these county resources, have him in jail, Harris County Jail, for 6 months, taking up a bed, have the public defender's office try the case with two lawyers, prosecutors probably have 2 prosecutors, jurors have 12 people, a judge, to use those kind of resources? I mean, if you really added that up, it might be $50,000 that's being spent.
Absolutely.
If not more, and we could calculate it because we know how much it costs to bed someone in Harris County. $50,000 for something that's not even a usable quantity of drugs?
Absolutely.
That's the problem.
And during jury selection, many jurors expressed that they were offended. One juror in the last trial was very, like, when they mentioned that it was a trace case, he said, "Oh, well, excuse me, let me get this straight, that we have 56 people here, and we have a judge, and we have all of this for a trace,
not
in
a
crack
usable
pipe,
quantity.
nothing that's hurting anybody." And he said, "I'm offended. As a Harris County taxpayer, I am offended about this trial." And I understand that. Now, but the flip side is the jurors will stay. You talk about how a jury's feeling, because that was what we talked about. Talking and going back and talking to both juries after the trial, they said, yes, it bothered them. There was a lot of resources, but they were going to follow the law. And the law is technically right now, those cases are at the discretion of the DA, and they are illegal. We don't have a law that quantifies. Now, some could say, well, let's solve this problem and quantify, because right now our law says less than a gram.
Right.
We don't have anything. So technically, both times in both cases, the lab techs got up there and said, I can't even tell you a weight. It doesn't even weigh 0.01. It comes back trace.
But the issue is, too, when you talk about the legislature, is marijuana laws were changed to where it has to be a usable quantity. And so one of the educational pieces we can take away from this is our cocaine laws, like Attorney Jackson said, is less than a gram, which is a sweet and low pack. But our marijuana laws say it must be a usable quantity. Then it can be weighed, and it starts with Class B misdemeanor under 2 ounces. But it has to be a usable quantity. I believe that we should be lobbying it for the cocaine
Absolutely.
to be a usable quantity. And I think that that's something that viewers can take away from this is it shouldn't be trashed because obviously if he has a crack pipe, if it's intentional, he has it for when he gets some more crack. You know what I mean?
Right.
If that's what he's using it for, or to give it to somebody else that needs it for some crack.
Right. Now, the
Or to put something else
difference between these 2 cases is the first that was a homeless man. It was one of what we know, or people are led to believe, is a homemade crack pipe. So it wasn't something that was designed to be a crack pipe.
What was it?
It was trash. It was just a little pin cap thing, part of a pin.
So like a pen?
Yeah, a
Like
pen,
a pen.
like a clear plastic kind of pen that had been
Look
makeshift.
at me on here, pen. So I have a pen in my hand. So it was a part of a pen cap. So it would be
No,
this
it
part.
was the
It was
pin
this part.
crack, like if you break it,
cracked
the
in
ends,
half. Okay.
I
got you.
and used in that way. Versus the other case, the second case.
Let's
that we
talk
can
about the
get
second
into.
case.
The second case was really a case that any of us, and this is why I'm talking, the difference is, a homeless person that may or may not have used crack and may or may not have been his crack paraphernalia. But in my second case, it really was an issue of being at the wrong place at the wrong time. My client had befriended a very elderly man in the neighborhood, been friends for years, had regularly visited him, taken him food. My client had no criminal history.
And how old a man was your client?
40 years old, had no criminal history. Unfortunately, the elderly man in the neighborhood, he had younger grandchildren or step-grandchildren that had lived in this big house, lived on one side of the house, he lived on the other. Whether the grandfather knew it, the 84-year-old man knew it or not, the younger 20-something-year-olds were dealing drugs out of his house. The police set up a sting, they sent informants in, and they got a valid search warrant for that location. Not known by the 84-year-old man, not known by my client. They had never seen my client. Witnesses will acknowledge in all of their observing for the amount of time they had watched this house and had sent people in, my client was nowhere on their radar. That day, my client says, oh, I'm going to take him some food, because he communicated with him regularly, pulled up at the house at the exact wrong time. Before he could even go inside the house, we call them jump out boys, showed up to execute the search warrant. This was a neighborhood house where people came. Unfortunately, it probably was a little bit of a crack house, but people played dominoes outside. My client was outside with several other people that had been playing dominoes, etc., but he wasn't with them. Police call, everybody get down. They go inside, execute the search warrant, and they do find a massive amount of drugs, and those people inside are arrested. During all of this chaos, by this time it's at night, the police admit 5 or 6 people in the yard, telling them all to get down. They find a crack pipe, and they claim that my client threw it. Now, only one cop, but there were 19 cops out there, and only one cop says that this one guy, he saw in the corner of his eye, he saw him throw a crack pipe.
Okay.
So it was just a matter of, unfortunately, in these cases, the DA's position has always been, we're going to believe our cops. If we have to go to trial, our cops say he saw it. No matter how much they think it's a possibility he couldn't have seen it, they go to trial on that. So
did y'all have pictures of the lighting at nighttime?
We had all of that, and we had the cops even acknowledge that it was dark, and that they were that they had to use flashlights.
Okay.
So the cops, I like to call them, I didn't call them during trial, but super cop, claimed that he got out there, he had his flashlight, he had his gun, he got everybody down, he was handcuffing and searching 2 people, and all at the same time saw my client hit the ground and throw a crack pipe. Okay. So I call him super cop. So in the end, successfully able to show, and the jury didn't buy that he saw what he saw. He was just mistaken. We didn't want to call him a liar because he obviously thought he saw something, but he didn't see my client throw a crack pipe. Now, bear in mind, my client had no history. He was probation eligible. He could have just gotten the standard 2-year deferred adjudication and gone on his way, but he was adamant. And he had no history of drug use, anything. As a matter of fact, he had a serious heart condition. He goes to the doctor 3 times a month to get blood tests and for his all the medications he's on, which in the end the judge wouldn't let us bring that in because our argument was trying to say that if he actually was using crack, he would have died. But the issue that we talked about a lot was the crack pipe. It literally was a crack pipe that my client says that he had never seen before. But the bottom line, they've got to put it on somebody. And they
Not
put it on
really.
him. Well, in their mind, they had to.
Right.
In their mind, they were going to. In the mind, this
I mean,
cop-
to me, if you find something in the grass and you don't know who it belongs to, tag goes to the runner. I don't know who it belongs to, particularly since their bust yielded a huge amount of drugs inside. Who got charged with the drugs inside?
Right.
The elderly man?
No, he wasn't charged. The 3 young people that were in there. Okay. But you have to realize, this is what I've learned through this case. The jump out boys were the investigative squad. They're the drug task force. The other patrol officers that just come and what
To transport, to try to keep the scene under control, handcuff people.
That's all he was there for. But he looks like hero because he was able to make an arrest. So, you know, in the end, he looked great. You got an arrest out of this. My client, our position was, my client ultimately, he did have a capious warrant. He owed some fines and stuff like that. That's what he believed that he was being arrested for. But and so it was easier. We've already got to take him in on this, you know, put the crack pipe on him.
Was your client a working man?
Yes, he was prior to, he ended up going on disability. So he was a truck driver and he was on disability. I think
Did he testify?
He did testify. He testified wonderfully.
What about the homeless man? Did he testify?
The homeless did not testify. It was not, he wanted to, but it was not in his best interest, and we made it through enough to convince him not to testify. Okay. Unfortunately, he had a lot of issues, but we were able to pull that off. But the issue is, at the time, I think our point of this is, what are jurors and what do the citizens think about our resources on these insignificant cases? I think they were a little offended. I think
on the second case?
Yeah, even so on that.
Let's split them up though. Let's talk about the second case. How do you think they felt about that one? Since there was a lot of drugs confiscated in that one. Right. And I guess that came into evidence.
Right.
And then there was a search warrant.
Right.
So all that came into evidence, at least through
the fact that the search warrant existed, and the fact that they made valid arrests that he had, and they acknowledged that he had nothing to do, and that he was never a suspect associated with that. So we were able to really clarify that. They didn't try and tie that all in together.
That's good.
Which we were grateful about. I think in the end they were trying to be fair, but it really was a one cop's word against my client's word. And the DA's position is always going to be that we're going to believe the cop, that we're not even going to take the position that maybe, as minor as this kind of case is, that maybe the cop just got it wrong. They didn't even want to take that position in this particular court, but in some courts they might have.
And before the trial, when you looked at the evidence in this case, what did it look like?
The evidence in the second case was a traditional crack pipe. It's something that you would go.
Was it in a baggie when it was thrown, or was it just a pipe?
It was just a pipe by itself. Can be described. It was a glass pipe, had a little place in there for the Brillo. It had a tip where they would smoke it from so they wouldn't burn their lips. So it was a real crack pipe versus the first case, which was a makeshift.
Now, on the second case, did the officers acknowledge that there were many people outside playing dominoes? But their position was that, I would imagine, that they had their eyes on them the whole time and never took their eyes off.
Absolutely. That was exactly
all of the reports say the same thing.
Right.
So I saw him and never took my eyes off
right.
of him. Okay. Now tell me what the jurors said after that.
I think they said that it seemed so obvious that it was no way that officer could be 100% certain. And so they were, were you a little offended by this? Yeah, this doesn't make any sense. Anybody could have seen. There were 19 other officers out there. Why did only one see this? So in the end, they did the right thing. The state did not make their case. They needed to see more than one. We always talk about that one witness. And in this case, this was the one witness. They can go to trial on a one witness. But a one witness.
Hold that thought for me. Let's take a call. Caller, thank you for calling Truth and Justice with Vivian King.
Hello.
Hello.
Once again, I missed first 3 minutes of the show, and apparently I missed a lot. Miss Jackson, she's with the public defenders.
You haven't forgotten. Thank you. And I've missed you. I haven't talked to you lately. How have you been?
I've been really good, thank you.
Good.
And I'm really baffled why the judge wouldn't allow the medical history in the second case.
I was baffled as well. I think the judge thought that it was not relevant. Our position, it was very relevant because it would go to his intent or his motive, which the state's position was they didn't have to prove intent or motive. They had to just prove possession of the crack pipe. our position, and the judge said to me while we approached the bench, and I had my objections, and while the judge said to me that it wasn't relevant because he could still possess a crack pipe but not use it. Nothing in our law says that the state had to prove that he was using the crack. And so that goes to what Ms. King said earlier. The sad fact of it is that someone could have literally picked up this crack pipe or object, they may not have known what it is, picked it up, and in the end, because we do arrest people for felony possession of a trace of something that had cocaine on it, they could have been charged with it.
And remember, the law is, caller, and I know you remember because you probably know as much about the law as we do, but it's intentional possession of it. And so if I pick something up, I'm intending to possess the pipe. I might find it interesting if I find something in the street. But do I intend to possess what used to be in it?
Right,
Because,
exactly.
you know, because that's the problem with cocaine trace cases is that you don't know what was in it because police officers are looking for it and they know that if they see that, then they can, you know, they can put their little dye pack on it and it's going to turn blue and they can turn it in to the lab and the lab will say they ran their little chemicals on it and it turned a certain color, but it's no usable quantity. So why would someone intentionally possess something that you can't use? I mean, so that's the silliness about the trace cocaine laws, and it's a felony that we're housing people on, whereas, like I said, marijuana has been, those laws were changed years ago, that it has to be a usable quantity. So, for example, if you see seeds in my car, if you stop me as a police officer, you see marijuana seeds, that's not a usable quantity, although you see the seeds and the stems. Mm-hmm. So I'm not going to be charged with it because it's not usable. It has to be, it has to be usable where you can roll a joint with it.
An example that I used in voir dire with the jury was if I, as a woman, I have a compact mirror and my friend says, oh, you have a mirror? Let me go to the bathroom and touch up my face. I give it to her. She goes in the bathroom, unbeknownst to me, and does a few lines of cocaine and gives me the mirror back. The way our law is designed, if I get arrested and by some chance the cop looks and says, oh, this looks like a little residue, and they do the little litmus test and it is, I'm now can be arrested for possession of cocaine because I possessed the mirror that had the cocaine on it. They don't have to prove intentionally possessing the cocaine, but instead, in this case, the object that had the residue.
Well, they're supposed to
right.
prove that.
Right.
But they switch it around.
Right. Their position is. I'm sorry.
Right.
Their position is.
Right. Right. No, but I mean, because you have to intentionally possess the drug. So if you don't know it's on there, then you can't intentionally possess it. Right. And that's what the jurors actually get right in these cases. I'm sorry. We started talking. Do you have another comment, sir?
Well, I'm getting some background feed there. This thing about the medical evidence, did the judge make that decision right in front of the jury, or was the jury dismissed for that?
Well, it was a decision in that the state objected when I was attempting to get it in, and I was brought up to the, it was just a bench conference. And the state objected. I attempted again to try and get it in, and I thought it was relevant. The judge gave me a little leeway, but in the end, sustained their objections.
It seems to me, I know we sacrificed a lot of things in society with the drug war, but this point, God, it seems so important that crack, he was a heart patient or whatever, and really, crack is not recommended, and how could the jury not hear that?
Right. I thought it was
agree.
very important. He's had congestive heart failure. He had a heart valve replaced 3 years prior. He went to the doctor 3 times a month to have blood work done to determine the percentage of his medicine, to change medicine regime. So it was no way that he was using drugs.
And the thing that's significant is if they got just 6 months of his medical records, if you're a chronic drug user, that would be in your medical records.
Right.
Even if you did it yesterday, it would have an effect on because it's a part of your medical history that's the problem. And so that it's very relevant.
But again, remember the state's position is whether he used drugs or not is not relevant. Whether he
Well, it is.
possessed it.
I guess the thing that bothers me about that, like it probably does you, caller, is our public policy. Men make the laws. I mean, our public policy, is that we're trying to stop bad things in our community and basically stop people from using drugs and buying it and using it. So if you're possessing it, I mean, why are we criminalizing it? But for the purpose of saying you can't have that drug. And if the person can show that I wouldn't have it, even if I picked it up, I wouldn't intentionally, knowingly possess trace cocaine. I would just be picking up some trash I found in the grass, looking at it, and that's not a crime.
Right. And in his case, he didn't even do that. But
I'm just saying
I think the
that's
issue
still
is,
not a crime. And so I just want to make sure that listeners understand that you can pick something up that's illegal. Now, because you look a certain way, the police might assume or presume that you know what it is, and if you look another way, they'll presume and believe your story. And that's the frustration, in urban America, is that if a black kid might say, well, I didn't know what it was, no one's ever going to believe them. But, maybe in another neighborhood, if kids say, well, I just picked it up, I was just looking at what it was, they might believe them, because sometimes kids don't know what things are. And so that's the issue. And it has to be relevant to the police, and to the DA's office. And like I said, jurors got it right, but they had to spend a lot of money to do that.
Right. And in the end, like what you talked about, picking trash up, the bottom line in many of our communities, things that everyone might think are trash can be made out to be drug cases. A case that I got dismissed, the same charge, possession of a controlled substance, less than a gram. Trace case. When we say trace case, that means that the lab came back and there was not a quantifiable amount, but could register.
I'm sorry to do this to you. Hold that thought. Do you want to ask me one more thing before we hang up, sir?
I guess I wanted to make the comment that it really baffles me that minor drug cases or even felonies is, we're wasting our resources when every week there's CPS dropped the ball again and there's another dead child. So I'll let you go with that thought. Thank you.
Thank you for watching.
Thank
Bye-bye.
you.
Thank you.
But on the lines of the fact that things that are thrown down that we don't even think about can be made cases to innocent people. Another case that thankfully the day of trial dismissal, but we were ready to go, we were willing to try it, was the same situation in the fact that it's a trace. And in this case, it wasn't a pipe. In this case, the police officer claims that at night he saw my client throw down a baggie. And we all thought baggie. You and I, if you hear baggie, we're thinking Ziploc bag. We're thinking, oh yeah, it must have had crack or must have had something in it. He saw a baggie, and my client was adamant that he had not had a baggie, that he had just come out of the convenience store and he had bought a cigar. He said, I didn't even take the wrapper off of it yet. But in the end, cop questioned many people around there, but supposedly near my guy's feet was this baggie that he says my client must have dropped when he was investigating. Well, we went, and how this case ended up going is we went as often as, and attorneys really should do all the time, ahead of time go look at the evidence. Because most of the time the DA is not going to see the evidence until it's brought there in court the day of trial. Well, we went ahead of time and looked at the evidence and took pictures. And the baggie that the officer claims he saw my client throw down at 10:30 at night in front of a convenience store with a lot of other people was literally, I've never seen a baggie this small in my life, the size of a piece of Scotch tape.
Wow.
It was a half of inch, well, probably 3/4 of an inch long and a half inch wide. I'd never even known they made baggies that small. But apparently that's something that you can get a crack rock or two in a baggie.
Well, they sure didn't make those bags for crack rock, so it's probably something medical for a pill or something.
Right, probably so. But in the end, thrown down at a convenience store with trash and everything around. So in the end, once the DA saw my photos I said, okay, jury's out in the hallway. You're really going to try this? And they looked at the picture and they're like, Because luckily my investigator was great. We put a quarter, when we took the picture, we put a quarter. The baggie was smaller than the size of a quarter.
Wow.
And that case went away. But that was a trace case that this county district attorney was all ready to try based on an officer saying that he had this amazing vision to be able to see somebody throw down something as they're walking out of a convenience store.
And I think a lot of times officers might see something get thrown or kicked around, but I just don't believe that they always know exactly who did it. And that's the problem and I think the quarrel that people have with that is that you're just going to put it on somebody because just because, and you don't say that you could have made a mistake or just picked it up and said, okay, so one of y'all threw this, next time somebody's going to jail, and just throw it in the trash. And so I think that's what offends people. I see that we have another caller. Caller, you're on. Thank you for calling. Hello, do you have an opinion?
Yes, I was calling. My name is Rodney. Can you hear me?
Yes, Rodney. But you need to turn your volume down and talk directly into your phone.
Oh, right. Okay. I'm sorry.
Okay, Rodney, what's your comment?
Well, I was prosecuted at one time for the distribution of crack cocaine, and it was in Kansas City where it's a non-tolerant, where if they catch just a bag on you, it's a felony. Mm-hmm. So what I'm saying is that it's a shame that people are being prosecuted for kibbles and bits. Okay, it makes no sense that I was in penitentiary and I'm sitting in jail with a guy that's doing 5 years of his life for a crack pipe.
Right.
And that's not a war on drugs. That's not a war on drugs.
And when I first became a prosecutor in '92, people were doing 25 to life on crack pipes. Okay, at least it became they created this thing called state jail felonies where they're doing basically 6 months to 2 years, but you could be a habitual criminal because there were only first, second, and third degree felonies, and your third felony was 25 to life on a trace amount less than a gram of cocaine. Mm-hmm. That law was at least changed, a long time, like in the early '90s. But that's crazy. But yeah, people were doing a lot of time, and they still can do a lot of time. I mean, if you've had 3 state jail felonies, you can be looking at 2 to 10.
Absolutely.
Listen, my out date was 2010. Mm-hmm. And what happened was the law changed in Kansas City where I ended up going on the one. Long story short, they called me 8 years later. I'd been to college and changed my life around, and I ended up getting a lawyer who used to be a prosecutor. A black lady, a great lady, and she got me converted to the new law. Wow. So I ended up doing a little time, and the little time that I was there, I realized that, I was talking to some people while I was in work release that, these guys were in jail for 10 years, lost their whole livelihood due to bags, like she's saying, little bags of cocaine, and really it's in the black communities. I'm gonna keep it real. These black people that have illnesses that are crack addicts, heroin addicts, that's not fighting the war on drugs by arresting these people. These people
I agree.
are they're ill. They're going to steal, people who are selling their kids for crack. That's an illness. That's sick.
Right.
I used to sell it. I know what it does to people. And God, praise God, I don't do that no more. I'm totally out of that life, and I'm a saved again Christian. But the reality of it is that police are going in communities. If you go into a hotel tomorrow, you never know if the police come in that room and they find a bag.
Right.
Then what? You get 10 years for something that you had no idea of, but you're in. Say you're in a black one of those hotels that are cheap.
Yeah.
Oh yeah.
They'll be there.
They're gonna be there. You lift the beds up, you see burns, you see it all the time, even in good hotels.
Yeah.
Right.
So the reality of it is that I think that those laws need to be changed because that's not a fight on. That's like if you're in a war and you got a bullet in your pocket. A little kid finds a bullet, it puts it in his pocket.
Right.
You gonna prosecute him, but the real people are the people that got the big guns. Okay, right. That's fighting the war on drugs, not little bags or little residues or weed roaches. That's why we are being discriminated till this day, and it's a way to lock up people.
You're right, Rodney.
Absolutely.
You need to contact me on my website and email me, and you need to come tell your story. But you're absolutely right, and that's why we want to put that out. And since you're doing the mainstream in society, you know, make sure that you talk to your politicians about this, your legislators, state representatives, even city council, because city council are in charge of the police. You know, the mayor is the one that appoints the police chief. City council deals with the police. So we need our resources to be used properly and advantageously. And as taxes go up, we don't want them to go up because we're paying for stupid stuff. I mean, we want to be paying for meaningful crimes. So I agree with you, and thank you for calling. And I hopefully you'll call me back again. I've never spoken to you before. Thank you.
Oh, I will. Thank you.
Thank you. Let's switch the subject and talk a little bit about marijuana.
Right. Very similar.
Okay,
situation.
tell me, Ms. Jackson was nice enough to research what our current two people who are running for DA, what their position is on marijuana when when police stop people for traffic offenses and they have a strong odor of marijuana in the car. Now, let me just say this before we start. This is a pet peeve of many lawyers because that's always the case when they stop a young black man, Hispanic man, the car smells like marijuana. Rarely do they ever find any marijuana in the car. Usually it's going to be something bigger, or it's going to be in a bag somewhere in the trunk, but it's never any evidence of marijuana that's been burning in the car recently. But that's always the probable cause because it's the officer's word against the person's word, and that gives them the right to search. But the law was changed in 2007 that allowed officers to stay on the street and not arrest people for marijuana. So let's talk about that.
Well, in 2007, so the way our law is now that, 2007 became, the state gave counties the authority to what they call to cite and release. It's a cite and release law that started in 2007. And so far in Texas, only 2 counties actually have programs of cite and release, and that's Travis County and Hayes County. And both of them have what the law is anything under 4 ounces, which is a small amount of marijuana. But here in Harris County, we still arrest. We still have people that we take officers. It can be, you know, we say joint. I don't know what they use, what term. It could be any amount that you can still get arrested and you can still sit in Harris County Jail. You might be in there 3 days, 10 days, 30 days, could be more depending on your criminal history. The way we work is it doesn't matter if this is your first little marijuana case, but if you have all these other cases, we're going to try and give you 60, 80, 90 days in Harris County Jail for a small amount of marijuana. The candidate running for District Attorney now, Kim Ogg, has come up with the proposed, and it's very organized, her GRACE program that basically is saying if elected DA, she wants to follow the cite and release. That means that officers, if it's a small amount of marijuana, will ticket and release the person, and they have a summons to come to court. And on that day in court, they'll have an option to do some community service. If they choose to do the community service versus paying the fine, then afterwards the case is dismissed and they have a right to expunction later on, that they ultimately can go file and get this arrest taken off completely. It's a very good program, a very good proposal. She's actually saying right now that she's proposing, if the amount's not, let me get this right, that the millions of dollars per year that it will save Harris County. As it stands now, I think her numbers are that we are spending, I don't want to misquote, $10 million a year on small marijuana cases. That's a lot of money. That's the amount of time, yes. The plan would save $10 million a year is what she's saying. That would come from keeping these people in jail, the prosecution costs, and last year alone, 12,000 people in Harris County were charged with misdemeanor drug marijuana possession, and they spent an average of 5 days in jail. That was the average.
Wow.
So taking that on, and then she's not only talking about on the other end, that possibly, I hate to say it, but possibly even if someone chooses not to go the community service route and to pay the $150, the $200, $300 fine, then we're talking about a situation that would not only save people money, but we'd also maybe be able to garner some income from the fines and penalties that some people would opt to choose to pay instead of the community service. I think that's a great idea for the taxpayers, and then ultimately, as a defense attorney, the problem is why the police are going to fight this is because then that takes their probable cause away.
Right.
And we see that because police use the smell of marijuana for bigger things,
Right.
to go to bigger things. So if you take that away and it doesn't give them, and I don't think the way it is that it would still give them an authority to search your car. I really do think they'd still be able to do that. But maybe it would take some of the other probable cause things that they use away.
Tell us what the current DA, Devin Anderson, proposes.
The current DA, and the thing that I thought was very comical is that we knew of nothing about the current DA's plan until the candidate announced her plan. And as soon as the candidate, Kim Ogg, announced her plan, when the press called Devin Anderson, she did say, oh, by the way, I'm working on a plan too. I thought that was comical. The difference is her plan would still require an arrest. They still would have an arrest. They still would be processed in the system. Just that if they had no other criminal record, to see if they'd qualify. She'd have a program that if you were a first offender or if it was a first whatever, or maybe depending on the type of priors that you would have, that then you'd be released then after it's determined that you'd qualify for the program. And that's about all that she's saying now on the program.
But she's not using that current program now.
Oh, absolutely
which
not.
Can be used.
She
So it
says
would
it's
only be used.
She says that it is in the works, that it's being investigated by the police department and the sheriff's department, and they're working out a possibility of implementing. Well, according to her, it will be implemented.
Okay. And let's just make sure our viewers understand cite and release. Cite and release is just the same as what we do now with Class Cs. If you get a traffic ticket, you get a summons that the police fills out all of your information on the ticket that you get, which that ticket is a summons for, running a red light or a stop sign. It's a ticket. He fills out all of your information. You sign it acknowledging that you know what date you're summoned to go to court, which is on that ticket. So the cite and release program for marijuana, instead of you being arrested and posting bond and possibly staying in jail an average of 5 days, like Attorney Jackson said, you would then just be given a summons. You'd be given a ticket, except this ticket wouldn't be for Lubbock Street. It wouldn't be for a Class C. You'd actually have to come to the big boy court, 1201 Franklin, and come to an actual misdemeanor court where you still are facing up to 6 months in jail or a year in jail, depending on the quantity of marijuana. But the issue is the officer does not have to arrest you. You do not have to get your car impounded. You do not have to post bond. You can just go about your way, signing that summons, knowing what date you have to go to court to defend possession of marijuana.
Absolutely.
And so, but that still means that when they smell the marijuana, they still have to take you out of your car. They still have to search the car and find the marijuana, if there really is some.
Right.
Or crack or whatever I guess they could find. But I think one of the morals to the story is we at some point in society have to get to a cost-benefit analysis.
Absolutely.
What is the benefit to society if it's costing us more and more and more money, and we can't really afford it? Because I always talk about when I was a teenager in the 70s, heroin was big, cocaine, marijuana was a felony, but people didn't get arrested for it. If police officers saw you with it, they'd throw it away.
Right.
Maybe heroin, but I mean like the marijuana that was a felony, or you had beer in your car. I mean, police officers just didn't get off the street for things that are silly, and now they do it all the time. Let's take a call. Caller, thank you for calling Truth and Justice with Vivian King. Please turn your volume of your TV down and talk directly into your telephone.
All right. Okay.
Thank you.
I'll turn it off.
All right. Thank you.
All right. Go ahead. Okay. Can you hear me?
Absolutely.
Hey, my name is Guilford Wells, and I go to St. John's, and I saw you at St. John's.
Okay. Hey,
And
Gil.
then I went down to the Breakfast Club, and I'm in recovery, but I want to tell you something. My father, I'm a recovering alcoholic and a real addict. And God loves me. I got stabbed in '85 on spring break, and I OD'd 3 times, and I flipped my car on 59. I want to tell you, God loves me. I graduated from Texas Southern University. I'm a counselor. I counsel adolescents. That's my specialty. My mama died, my girlfriend died, and my daddy died, and my stepdaddy died, and I got high. No matter how high I got, they still didn't come up out that ground.
I know
was
that's
stuck to
right.
the
That's
addiction.
right.
I want to tell you something. I've been admiring you. I saw you at the Breakfast Club, and I want to tell you something. I'm building a transition, like at St. John's, one of them transition living center for the homeless in Victoria. My daddy died, stepdaddy died, and he left me 7.5 acres
Okay.
in Victoria, Texas, and the only thing I'm having a problem with is my 501c3.
Well, we're not going to talk. We're not giving out any legal advice. All we want you to do is comment on what we're talking about, the trace cases tonight. So tell me what you think about the trace cocaine cases,
The who?
the cocaine cases that we've been talking about. What do you think about those?
Oh well, I'm a recovering alcoholic and an addict. I hit that dope, and I got a dope case on in 1996 over there on West on Airport.
Okay.
With Airport, yeah. Over
Okay.
there on Brazewood, like in Brazewood.
Okay. Guilford.
And
Guilford.
I got a degree and everything, but I'm
Guilford.
gonna tell you something.
Guilford. We appreciate you calling in. We're going to take the next caller. Thank you for calling, and please watch us again next Wednesday. Good night.
Okay, boy.
So anyway, we have 6 minutes. So was there anything else interesting that you thought about in those articles?
Well, like I said, in the end, that they're talking about the money that they can save up to $10 million a year. That's a lot for taxpayers. That would fund some other programs that are not getting funded right now. Ultimately, and compared to other states that are legalizing marijuana, I don't think Texas is ever going to get there anytime soon in my lifetime. But in the end, when we have the authority to cite and arrest, as a taxpayer, are we offended by the fact that we're spending all of this money?
And are we offended that a small elite group makes that decision? I mean, because what offends me as an educated taxpayer is that the law changed in 2007. Does the media talk about that? Do they talk about does the news talk about the cost effectiveness of the arrest? Do we talk about things that could save us as taxpayers money? Because even if it doesn't fund other programs, it could keep our taxes low.
Right.
I mean, how about just not raising our taxes?
Right.
I mean, because
right.
the rest, from the beginning, your whole life as a taxpayer, taxes go up, 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 up.
Right.
Whether it's sales tax, whether it's property tax. I mean, all of these municipalities are affected by the city of Houston getting the tax on your products, right. the county getting money from your homeowners from owning real estate. I mean, but it's all affected by the sheriff's department being the county, and so it's so many areas that are affected by it. Why not save money where we can? And it bothers me that our taxpayers, the people in charge, one candidate will decide, and people don't really think about the fact that we need to make noise about it.
Absolutely. And then at the money that we save as individuals, not trying to say, and I'm not, some people would say, well, these people are breaking the law, marijuana is illegal. But for a case as insignificant, and I'm sorry I used the word insignificant if you're offended by it, but I think a case of less than 4 ounces of marijuana in the scheme of things is insignificant. That you're taking our resources, police officers off the street, the 3 hours that it takes to book this person in. This cop needs to be out here doing something else that's more important.
Making sure our houses are not getting broken
Making sure our houses aren't
patrolling, making sure people are not running and looting.
Absolutely. So you're taking away significant resources and time for something that's I use and I'll keep using, to me, insignificant. Because in the end, they're going to end up getting, as we talked about, arrested, having to make a bond anywhere from a few $100s to as much as $1,000, depending on the amount.
And the thing is, let's talk about this. How has marijuana hurt society? I mean, it's not like, we drink alcohol, and we know we have a lot more DWIs and fatalities based on alcohol. And let's talk about something else to be real. people using their cell phones. People using their cell phones, texting and driving is much more dangerous than anybody drinking and driving or being on marijuana and driving.
Right.
But we're not outlawing that because that's capitalism. That's
Right.
people making money out of it. But it's dangerous when I do it.
Right.
It's more dangerous if I do that than if I had a drink and drive. I'm just telling you.
Marijuana cases are not leading, and even and I think the DWI lawyers will tell you the number of DWI cases that involve marijuana is a very small percentage.
It is.
As compared to alcohol. That's the bottom line.
And the long-term effect. I mean,
Right.
people die of cirrhosis of the liver. We have all kind of alcoholic-related health issues. But how many health issues have been attributed to marijuana?
Right.
A natural plant.
Just laziness. But
Just laziness, a natural plant. But obviously, if it's induced or laced with something else, then we're talking about something different.
Right.
But we're just talking about marijuana in it. So that's the thing that makes it. And I think as the baby boomers have gotten to be grandparents and they've looked back and they know they tried marijuana, a lot of them are probably still sneaking and doing marijuana if they go to Amsterdam or somewhere, and they realize that they've known people for 50 years that have smoked marijuana and nothing bad has happened because that's all they did.
Right.
So I think that it becomes society has to relook at where we spend our money, and we just don't let a small group of people tell us how to spend our money.
Absolutely.
We should have a voice. So we have 2 minutes, and I would love for you, Attorney Jackson, to try to wrap up the moral to the story when it comes to jurors' attitudes and on crack cocaine.
I think the moral to the story is that right now jurors are getting educated on the fact that Harris County is pursuing trace cases of drugs, spending taxpayer dollars. They will follow the law because the law is the law that it is, but we need to do a few things. We need to determine, are there alternative ways of trace cases? And I'm not talking about, the few rocks that people are
We're talking about non-usable quantities.
Non-usable quantities.
Right.
And I want to make that very, very clear that that's a significant difference. And I think right now that's being a little abusive. It's abusive prosecution. It's abusive to the individual. It's abusive to the taxpayers. They try and say that they don't prosecute addiction, but that's what you're doing.
Right.
Because if they don't have anything left, what are you arresting them for?
Right. For something that can be used if they get some more crack or given away.
Right.
And it's offensive. I mean, we have taken people's civil rights to the end. And so, our individual rights. Because if I pick something up, I shouldn't be afraid to keep it because I don't have a dye pack to tell if it used to have cocaine in it.
Right. And I think ultimately the former district attorney, Pat Lycos, got it right when she said, and she took the position that she wasn't taking trace cases. Now,
and the thing that's sad about that is she did that for the good of the people. We had less cases in the courthouse. People's cases the real cases could be dealt with better, but that was taken away because people didn't understand that. And she was bold to do it, and she lost her job behind it. And I'm not saying she shouldn't have lost her job. I'm not really into that part of the politics of it, but it appears that was the reason.
Right. And I think ultimately we're making a distinction here, specifically trace cases, not the ones that are .01.
We're not talking about usable quantities.
We're not talking about usable quantities.
We're not talking about some crack where somebody can put it in a pipe and smoke it. We're talking about when there's nothing to smoke, when there's no usable quantity. Right. But anyway, I'm getting the signal to wrap it up. Right. So that 1 hour, even without commercials, goes by very fast.
It does.
And I want to thank my guest and friend, Juanita Jackson, for taking her time out to come and educate us about trace cocaine cases, non-usable quantities. Mm-hmm. And she has a cold. She's about to take antibiotics. She's sick, and she still made her commitment to come and educate us. And I want to thank you for that, and I appreciate that. And thank you for watching Truth and Justice with Vivian King. And please watch again next Wednesday when I bring you another interesting and educational show. Good night. Thank you for tuning in again tonight. We have something really good, a hot topic in the news this week. He's been charged with crime. This is a show where I try to educate real stories. good. Hot topic in the news this week. He's been charged with a crime. This is a show where I try to